SJC-12022, Commonwealth v. Josu R. Molina.
Mr. Stiles, good morning, but why don't you wait until we get the clock to tick. All right, please proceed.
All right, good morning, Chief Justice and Justices. I'm Ethan Stiles, and I represent Josue Molina in this case. There are three issues in my brief, and I'll be talking about them in the order which they've been presented. So first, I'll start with the warrant in this case, which we allege is essentially a general warrant to seize and search all computing devices and just about anything else that you could think of, given the language in the warrant itself. And we challenge that as overbroad as both to persons whose properties to be searched and the things to be searched as well.
What things were to be searched?
Well, if you look at the language, which was generated by the police and adopted by the justice who issued the warrant, it talks about lots of things. It talks about computers and computer-like devices, storage devices. It talks about correspondence, records, notes, bills, account statements, digital file, data, information in any form. So if you look at the language of the search warrant, which is included in the record appendix, you'll see that the language is very broad.
So that is to search the contents of those devices.
Search for the devices and the contents of the devices.
Right. So you have two separate claims. One is that the warrant was overbroad as to the devices that were seized.
Yes.
And then you also have a claim that the warrant was overbroad in terms of the material that was on the devices that could be searched.
No, Justice Lang. My second point is that the warrant is overbroad as to the owners of these devices, and as well as what devices can be collected.
So it's only with respect to the two points that Justice Lang meant. The only one you're challenging is the devices themselves, not what could be searched on them. Just the number, the number and variety of devices. Is that right?
No, actually, I believe that both claims are sort of intertwined because because if you look at the language of this search warrant, the police have virtually no limits on what they can search for when they have these devices. So, but first, obviously, they have to find them.
Let's talk about why couldn't they just get all of the devices?
Why
Wasn't there probable cause to seize all the devices? They had information that IP address, which could be one or more computers at that address, was implicated in child pornographic materials.
They had that, but that's all they had. That's all they had. Judge.
So that's pretty good.
I would tend to. Well, it's good enough perhaps for a warrant that there would be probable cause that some evidence of child pornography might be at the residence, but it doesn't necessarily follow that the possessor of the child pornography is going to be at that residence.
No, but the child pornography. I mean, I think step one is the devices. We've got the IP address. So isn't there probable cause that there might be child pornography on computer devices at that residence?
Well, there may be probable cause to suspect that one computer might have evidence linked to child pornography at the residence, but I think that's all because the dissemination or the distribution appears to be from one computer hosting the child pornography, which is what the police download.
Well, not one computer, one IP address, which could have any number of computers at that residence.
But I believe
not linked to one machine.
But I think it's linked to one account, and therefore that would suggest that there is one machine here that's hosting the
Your
file.
position is that they should get a warrant that says we should search for one MacBook with a particular registration, and then when they go in there and find an iPad and an iPhone, they can't search it or seize it?
Well, Justice Casiano, the next point I want to make is that that these devices, that this is a shared living arrangement, and that many people live here, and that ultimately, if the warrant says go to this apartment, take all the devices and search them, I would suggest that's overbroad in the absence of further investigation. That's going to determine if it's possible, what these devices are and where they can be used. I mean, because essentially you have the situation where you have, a home that could have, 20 computing devices, and the police go and they start searching, and it's not, they search 19 devices and they find them clean, and the 20th device they find the child pornography. And at that point, then you have the issue, then the issue is still overbroad. And I don't think it's necessarily safe because they happen to find it.
There are two different things, though. One is to take the machines. I mean, it'd be clearer if there were two warrants, two separate warrants, one for the machine and one for the contents of the machines, as they were in Dorellis. But they're not. They're just one combined warrant here. But let's just take that portion of the warrant that looks at the seizure of the machines, the devices. And why wasn't there probable cause to seize all of those devices that were attached to the same IP address?
Well, because I would suggest that that we don't have a situation where, I think in one of the cases I cited, where you had a single individual living alone, and he may have had a record, he may not have had a record. But here we don't have. But we have what the police know at the time they apply for the warrant is they have a house with at least one apartment, a mailbox with 5 names on them, and one of those names happens to be the account owner to whom the IP address is assigned, and that's it. We don't know anything else about the people inside. We don't know, for example, if there's a registered sex offender at the house. We don't know, for example, if there's an open Wi-Fi access at the house. We don't even know really who lives at that. Who lives
That
there.
much?
What?
Do you need that?
Well, I would suggest when it comes to focusing when it comes to avoiding the overbroad warrant, I think the police should be able to show what their investigation was to try and narrow the scope of the search to the things likely to hold child pornography.
What else could the police have done? What else would they need from your perspective to avoid this overbreadth that you complain about?
Well, first I would suggest, that they could do such things. I think I just mentioned something like check the sex offender registry to see if there's any registered sex offenders living at the address. Check the registry of motor vehicles to see who's actually living at the address, since that's the most likely reliable source. They could check the building department to see whether this is a legal two-family and whether it's a true.
Didn't they do that? You argue in your brief that the warrant was under-inclusive because it didn't include the other apartments.
Yes, I mean, because in this situation, it very well could be a shared access where everybody was sharing Mr. Delcede's internet connection. So, I mean, ultimately, it could have been the people in apartment 2 or 3. I don't know how many apartments there were.
Well, suppose you didn't get any information from doing all of the things that you just described. They still just know that there's one subscriber with this IP address, but there are 4 other names on the mailbox. Would the fact that they had done all those things mean anything for the probable cause inquiry?
I think it would, because if they had done those things and shown to the judge that, listen, we've done anything that's reasonably practicable, we can't do anything more without jeopardizing our investigation. We've done our duty to try and protect the privacy rights of the innocent as well as trying to investigate the guilty here. Judge, please give us our warrant. I think that might be enough to show that the police did, take reasonable precautions to try and protect privacy issues in this case. Or especially when there could be the situation where the pornography is not on that the pornography is not on the premises at all, except for what might be temporarily on the computer because the computer has been hacked and someone elsewhere is using it as some kind of dupe or a zombie computer, I think it's sometimes called, to access the files remotely and cover his tracks. So ultimately,
Between what you can find when you get into the computer and whether you can take the computers themselves.
well,
And why can't you go in, based on this information, that you have this IP address which is yielding child pornography, according to the state trooper who has been doing the exam, I think it's the state trooper who's been doing the examination, linking it to that specific physical address. But you don't know if you go in and you see 12 machines, which one of those devices might be the one that is yielding the child pornographic material. Why can't you still seize all of them?
well, I mean,
Without knowing which one or ones have the information, but just that it's reasonable that somebody's machine is going to?
Well, I mean, I think, in that instance, in this particular case, the police, had the good fortune of going into Mr. Molina's bedroom and finding the laptop open and the file sharing program up, and they say, oh, there it is. Now, in that case, I would suggest that at that point they've already talked to him outside, they know what's going on, and now they can apply for a second warrant that says, okay, we need to seize all of his stuff because now we know who we're dealing with. And at that point, we no longer have to worry about the other people's stuff unless there's information that would suggest that
But
they're
aren't
also
we looking
involved.
at the warrant at the time it was issued, not at the time that it was executed?
Yes, and that's why I suggested that the police should have asked for a more narrow warrant,
Which would say what?
Yeah.
which would say, based either we can't narrow it down, or based on our further information, we believe that this because for whatever reason, perhaps they use some sort of program that can somehow identify the particular computer involved, that we believe that this is going to be an HP Pavilion 2000 or 2500, and we're looking for that computer.
But that doesn't take into account the fact that there's a router and people that are accessing child pornography on a particular IP address can use a laptop, they can use a tablet. It doesn't,
Yes,
it's like digital whack-a-mole. You don't know where it is, right?
well, some law enforcement agencies may be technologically sufficient that they may be able to get a warrant that might be able to help them identify the particular computer, perhaps with the assistance of the internet service provider, sort of like essentially a digital wiretap of sorts, where they can look at the traffic and analyze it and make conclusions as to who it is and what. But we obviously don't know what the capabilities are in that situation. The police have never, suggested that they tried that and
Well,
would not be feasible.
they're being investigated by the police, not by the NSA. I mean, there are limitations, reasonable limitations in terms of what is knowable with regard to these investigations.
Yes, but I think when it comes to privacy, the court should have the police explain those limitations and say why we can't get more specific. But here we don't have that, or any attempt to really try and narrow down the list of suspects. Now,
If I can turn you in your last few minutes to the lascivious intent issue.
Okay.
Let us assume you are correct that the possession with intent to disseminate includes a lascivious intent requirement. Does it have any consequence in this case where this was a bench trial, so there are no jury instructions, and the judge found him guilty of dissemination where there clearly is a lascivious intent requirement? So why would it, even if you're right, why would it matter?
well, the Commonwealth argued. I believe they argued in their closing argument that it was not required, despite the indictment that says otherwise in the statute, which I think should be read in the way that would require it. Otherwise, it would punish innocent conduct of similar nature. But anyway, but my argument is that the evidence does not show that Mr. Molina had a lascivious intent when he set up this program that automatically uploads what you download. And I think you'll find that if he is indifferent to it, that is more of a general intent crime.
But couldn't,
Is it,
given the nature of the Ares program, I mean, doesn't it sort of go with the territory? That you're uploading and downloading, and so once you sign on, I mean, you seem to make this distinction whether he actively did something as opposed to just letting it run, but the fact that he joins he buys in, doesn't that matter?
Well, it might be Justice Bosford if he could, went and joined a child pornography site or group. I think there's some federal cases that talk about that, and they find that significant. Whereas Ares can be used to download anything, and I think I think you'll see if in the exhibits, I think the Commonwealth put one in color there that showed that he was downloading many things, some of which were not pornography. I think there was like movies and music as well. So, I mean, so essentially, we don't have that, nor do we have anything else that would suggest that, yes, that he was actively involved in trying to, spread the material, where they are in other cases. And I would even suggest, and I would even point out that that he had cache that they found 3 caches of material, but not all that material or anything near it was in the My Shared folders where the people could upload from his computer.
Okay, thank you.
Thank you.
Mr. Furch, good morning.
Good morning, Mr. Chief Justice, and may it please the court. Ryan Furch on behalf of the Commonwealth. With me is one of the trial prosecutors, Nancy Rothstein. The Commonwealth requests that the court affirm the judgments of Mr. Molina trading in child pornography, but remand for a proper restitution hearing. And this is a rare case in which we know one of the victims of the child pornography trading. And the trial court judge made a mistake by a belief that that victim had to testify at the restitution hearing.
Can I just,
Sure.
you'll get there, so why don't you talk about other
Yeah,
things
yeah,
first?
Let's begin, if we can move, I mean, you've got a lot on your plate. So, in this case, is it troubling to you that you realistically had evidence that only one person of the 5 was engaged in child porn, and you've seized the computers arguably of 5 people?
It's not troubling for many of the points that were already raised, because the question is what was knowable at the time the search warrant. Okay. And it's a point that I want to make out. The search warrant was not for people, it's for data. And specifically, it's electronic contraband that can be moved between devices.
Could I ask you a question about that?
Sure.
I'm sorry, Chief.
No, you've got your question all set. I can save mine. Go ahead.
Well, my question is about this concern. It reflects my concern that the courts are following the police as far as what they say they can do within technology. Why should the courts accept what the police say they can do or what they can find out? Isn't there a point where we expect the police to develop technology that would protect privacy of potentially innocent people? I mean, that kind of tags on to the chief's question. You have 5 people living here. And as it turns out, the person who is the subscriber is not the person who is possessing the technology. I mean, doesn't there come a point where we expect the police to do more from a technological point of view to accommodate these privacy concerns? I mean, that's a bigger question, but it's one that bothers me about what happened in this case.
You're right, it's a big question, so let me try to tackle it the way I can. The police here are actually combating privacy that is protecting these individuals. And let me explain that. As was pointed out here, what is publicly known as an IP address that just points to a physical address. We don't know, and the police cannot possibly know how many devices are within that address, who has access to which device. And so in that way, people have privacy. I agree with you. The police probably shouldn't, and they can't currently know whether you have a laptop, in which room that laptop is in, which device, and that's part of the issue that they're combating here, and that's the issue with these warrants, that they are as narrow as they possibly can be given the current state of technology.
They
that's
are
the
and they
point.
aren't. I mean, it was narrow in terms of the devices themselves, because, I think it's probably not unreasonable to think if you've got an IP address that attaches to a particular physical address, and you don't know, you assume because of a router, and you assume that they're sharing, that multiple devices could be sharing the same IP address. It's one thing to go in and get the machines, but here, the warrant is not just seeking the machines, it's seeking this wholesale exploration of the contents of all of these machines, bounded only by this notion that they're going to be related to crimes of child pornography. And that, of course, means that all of the devices of all of the people who live there could be subjected to this sweeping investigation of its contents without any attempt to limit those searches.
Well, there were delineated searches of what was allowed to be searched for on those devices. It was a narrow category of child pornography, and again, this,
I mean, you could go through, you could rummage through the entire computer for all of those things. And I guess what I'm saying is, I think the literature favors having 2 warrants, one for the devices themselves, and then once you have the devices firmly in hand, you go in with more specific search requests. And here, you could even have done it, it seems to me, maybe I'm wrong, maybe, but it seems to me you could have had like the initial sort of, you knew that there was this software that somebody had. You don't know on what devices it is. So that you could have, in fact, had as an initial search, perhaps, even in the first warrant, that you could go looking for who had that software. And that would eliminate some of the devices, wouldn't it?
it wouldn't. There's a couple things I'd like to get to answer that question. It wouldn't limit it because of the transferability of the contraband here. Just because you have the Ares program doesn't mean that the videos or the images that are contraband are going to stay on that device. As was demonstrated when they showed up, there was an attached hard drive, there was other devices that had it on there. Certainly the Ares program, and again, it's worth pointing out the Ares program itself is not illegal. You can download plenty of those documents.
But that does sort of narrow the field in some ways. I mean, there are ways, it seems to me, that it could have been narrowed. Plainly here, it looks to me like as a result of the somewhat fortuitous run-in with the defendant in his car and the search that was going on simultaneously, the focus was on the defendant and his bedroom. But I forget the name of the people who...
The Delcids.
Yes. Their computers were also examined, but quickly, apparently.
And that's, I would like to touch on the idea of the double warrant. I think the question about having a second search warrant here is whether or not that would be more intrusive. Because with the second search, looking at the facts of this case, the Delcid's computer was searched in a matter of minutes and ruled out. If you have an initial warrant to go in and grab every electronic device without containing search terms for what's on them, what would happen is the police could go in, grab every single device that's in that residence, take it back to the lab, apply for a second warrant with specific search terms, presumably including the Delcid's computer, to get back to the lab to run searches on those computers, which arguably we wouldn't really have much more information at that point than we had when we executed the warrant. The only additional information we would have is which devices there are. And the Delcids would have been without a computer for much longer than they were in this case.
So, but does that speak to the need for there to be at least minimization protocols? I mean, if you do a wiretap, there's a statutory requirement to minimize with regard to conversations with persons who are not targets or conversations that are with attorneys. Shouldn't there be some obligation here as part of the reasonableness of the search as opposed to the seizure to have a minimization protocol both to eliminate the Delcids once you discover that they're not the people likely to be involved, and then also even with regard to the target to be separating out love letters from child porn?
Well, then I'll take that question in two parts. The first part gets to how this search is used, or how these devices are used during the execution of the search. They are used not at that time necessarily to find all of the contraband. They are used to further interviews, further the investigation that is there. So they are used for the purpose of ruling out certain individuals and to figure out on which device this contraband is and who has possession or control over those devices.
So that's what you use the search terms for?
No, that's what the devices, when the search warrant is executed, when the police go in and find, so here they go in, they find multiple devices, they're trying to figure out.
They're using search terms, are they?
No, I'm just talking about the physical devices.
Right.
They
but
have
I
to
mean,
do a search of them.
They do a forensic examination.
But
of them.
like when they go in and they search Delcide's computer, I mean, what are they doing when they do that?
There's evidence in the record of that. That was from the on-site digital evidence. His testimony began on the second day on page 78. He talked about he didn't do a full forensic examination. He did a very quick, and it's unclear whether or not this was consented to or not. But he did a very quick review of the internet history and search terms on that computer and quickly ruled it out within a matter of minutes.
But he could have, under the terms of this warrant, they could have taken all of the equipment back to the office and exposed all of the equipment to an extensive forensic examination.
And that gets to the second point I was going to make. It's a matter of how these examinations are done. And I think the best analogy I can come up with is it's like running a Westlaw search. You're not going to go through every single case on Westlaw one by one to try and find the matter that you're looking for. These forensics examinations, we're dealing with copious information, but the search warrant's clearly defined, and there's evidence from the troopers here that they look at the search warrant before they begin their searches, and they're running, and it's in the office's best interest to run narrow searches within the computers to find the information.
But don't we have to look at the warrant and what the warrant authorizes, not just, I mean, what you're basically saying is we look to see how it was executed.
Well, it's a combination of what the warrant authorizes search for child pornography and information about who owned, again, going back to what we didn't know, who owned the computers and who had access to the IP address. It's a combination of what the search warrant authorized and how the execution was done.
And so when we look at the issue of reasonableness, and it's ultimately a reasonableness test, do we not need to look both at the reasonableness of the search and seizure, and then secondly, the reasonableness of the execution of the search?
When you're looking at the four corners of the search warrant as to whether or not it was overbroad, I think
That's purely the reasonableness of the search or of the seizure.
in terms of the actual seizure, I think you can look, and I believe, I don't have them on tip of my tongue, there are cases that have looked at how the search is done. And there is a lot of evidence from Trooper McCarthy about how exactly this evidence is handled and how the searches were done.
And it may be that you had essentially your own minimization protocols in place and acted entirely appropriately, and it sounds as if the trooper did the right thing to do some initial search of the Dell Seed computer and say that's out, which is exactly what you'd want. What we want to happen is to eliminate the innocence from the scope of the search. But should that be something that's part of the reasonableness of the execution of the search that we should be judicially requiring?
Well, I don't...
Not with regard to the four corners of the search, but with regard to the, so a defendant could make essentially two claims. One is you didn't have probable cause for the search, okay? And then the second one is, okay, you had probable cause for the search, but the manner in which you executed the search was overbroad in terms of not appropriately minimizing for irrelevant or innocent communications, which we care about because a computer contains everything in everyone's life.
I think a defendant already has that argument. It's under the exclusionary rule as applies to searches already. There's already an argument that, let's take it out of the context of computers. If you show up and you have a search warrant for a single apartment and the officers end up looking at every apartment in the building, a defendant has the right to move to suppress, saying that even if proper when issued, the execution of the search warrant was overbroad and the evidence that was found outside.
But that's easy. I mean, once you get into the searches of laptops with all the information contained, it's a much harder analysis.
It is. And I think that's why it's important to look at what was done in the actual case. And I also wanted to point out on that point that the four corners of the search warrant do include some of this information about the use of civilians and how that examinations would be done both on site and I believe back at the lab, because there is information in there about the transportation of the devices to the Attorney General's lab.
Do the not in the search warrant itself, but just as the Attorney General's cybercrime lab policy, are there protocols about doing this, weeding out kind of preliminary search to try to zero in on what matters and what doesn't, and so you can return or not take what matters? Is there not a required, but a sort of, it's like a minimization policy, that's exactly probably what it is, but does that exist, or is that a case by case and you just depend on the trooper's training? How do you work that?
It does exist, and I would suggest there is testimony in this case from Trooper McCarthy about the steps that he used and the policies of the Attorney General's office about how evidence is handled, how the searches are done, and what's up.
That's not part of the warrant application.
No, it's not part of the warrant application itself.
That could be.
It could be. I think there needs to be some caution there because, again, going back to what's known, we don't know every device And I think the searches have to be on a case-by-case, device-by-device basis. For example, a search of a tablet might be different than a laptop, might be different than a USB.
Right, but I mean, it's the fact that the warrant seems to authorize a very, very sweeping examination of all of these devices without any indication that certain protocols will be followed to minimize the search.
And my point on that is it would be difficult to develop protocols without knowing which devices there are beyond what search terms or white
Well,
information and evidence would be, and
Of course,
contraband would
then
be looked
that
for.
speaks to the desirability of a second warrant, when you would know what devices there were.
And again, it gets back to my point, if you're going to include that, perhaps then a second warrant would be better. But as this case unfolded, a second warrant really wouldn't have added any more information other than which devices were seized.
I'm sorry, the warrant itself provides authority and was presented to the Superior Court judge to seize all the devices, but it also says because this is complex, we're going to have to take them back with us.
Right.
And use civilians. So it actually gave more authority to the police than the quick look that happened in reality at the scene, correct?
Correct, and that's my point, that it was in the search warrant. The magistrate judge, when he signed this warrant, was aware of what was going to be done.
Well, assumed that the machines were going to be taken away, right? They were going to be taken out of the house. That's what the warrant suggested.
Right. And that's what the warrant advised the magistrate judge
Right.
was going to be done.
Right,
It's-
so,
As a practical matter, if you're doing child porn investigations, which obviously this team, I forget its full name, but yeah. So is there a sort of common set of search terms or something that have, I understand devices are different and cases are different, but is there some sort of common core that can be articulated of what you look for, how you do it?
Of search terms in particular, I don't know the answer to that. I can point to the fact of this case, every file has a hash value that's a specific numeric. We knew in this case from the videos we were able to download from the defendant, what became the defendant's computer, that we knew those hash values, so we knew, and that's.
That was from this
That's how you managed
that's
to-
what you did before, right? Didn't that form the
We
probable
knew that
cause?
information before, and that helped. So for example, when we got to the site, we knew he was running, we knew a computer was running Ares. We knew certain hash values were there. What the forensic examiner attached his software to the laptop, was able to see just a quick file structure that was on the computer, saw the Ares network, saw the shared folder, looked at one hash value that was there, confirmed that yes, there is a video that is absolutely clearly child pornography. We're going to take that back to the lab and run more detailed searches looking for this information.
but when you looked at the Delsey's computer, you could do it quickly and see that they didn't have any of that stuff?
There was a quick, my understanding of, and the testimony admittedly was brief on this, he said he did a quick look of I believe just which programs were on the computers, and a quick look at the internet history, and determined that there wasn't anything there. And the computers were also, again, part of it is fortuitous based on Mr. Molina's computer running, and not just running the Ares program, but trading in child pornography when they showed up, that it was pretty clear.
Before you sit down, with regard to the restitution hearing concerning the claim for restitution of one of the girls whose photos was on the child porn, Vicky, assuming that hearing can be done based on reliable hearsay, did the judge essentially find that I'm not prepared to rely upon the reliable hearsay in the circumstances of this request, and I think that I will need to hear from Vicky? Is that an abuse of discretion for a judge to say, under the circumstances that you have described, I don't think I could find that it's reliable hearsay based on the affidavits, and I would need to hear from the witness? And you're essentially saying we're not going to bring the witness, and therefore there's no need for a hearing.
I don't think that's how it happened in this case. The way it happened, the Commonwealth submitted that they wanted restitution. The defendant disputed it, said, I want a hearing. Judge took a quick break, read the Casanova case. His reading was, well, if I have a hearing, I'm required to have the victim here, and that's where I contest that's a mistake of law, because that's not what the case says. And then from that, it all flowed backwards to, I'm not going to have a hearing. When I can't have a hearing, I can't award restitution.
The Vicky.
Yes.
I take it, given the nature of this, the video, it can go virally, it can go around the world. Does that mean that Vicky can recover? I mean, how does that work?
It's
So
troublesome.
I
I
take
mean,
it
that's,
Vicky got $8,000 from another judge in Essex County? I mean, even in this Commonwealth, right?
it can, and it's a double-edged, I would recommend the Paroline case from the US Supreme Court goes into this a lot, and part of the problem for these victims is exactly the viral nature. Their privacy is being violated every time their movie is transmitted, and every time
I'm
it's,
sorry.
go up.
But is it relevant that, I mean, I guess there's a reference on the reply brief, page 26, that as of 2013, Vicky had been awarded already approximately $600,000 in restitution? That she had collected that much? That she was awarded $1.2 million in all these cases and had collected about half of that? Is that something that a judge may consider in deciding this issue?
I think that at a proper restitution hearing, I think that would go into a factor of what request or what amount is being requested in this case, whether or not it's reasonable. Again, I point to the Paroline case, which under the U.S. statute was requesting $3.4 million from one person because that was the reading that they could request all of their restitution. Here it was only $3,900. So I think it could go into the reasonableness of the restitution from an individual defendant. And I would suggest, given that this Commonwealth is much...
Say it's irrelevant that she already has 600,000?
I'm not saying it's irrelevant. I think it could be relevant to the amount that's being requested. In other words, she's not requesting $2 million from one
But
person.
minus. I mean, I don't know.
I mean, and this is where I fall back on the fact that the restitution standards in this Commonwealth are flexible and intended to get proper restitution to victims, and it's a reasonableness inquiry for them.
But is there still a causation requirement that the defendant caused the harm?
There's a nexus requirement between the two, that there's a tie between the actions and the harm to the person, and I think both the Paroline case and other cases that have dealt with child pornography have all agreed that there is some nexus between, and clearly there's a nexus in the dissemination of these videos.
And when you use the word nexus, do you mean to say it's something less than causation in a civil case?
I think, based on this court's opinions, that's the phrasing I believe has been used as opposed to causation, as opposed to a pure but-for and proximate cause. And I think, again, I point back to the Paroline case and the discussion amongst the justices there. The problem isn't with proximate cause. The problem is with the but-for cause. And I think if you're going to graft that statute on in the context of victims of child pornography, it's going to be extremely difficult to show that.
All right, thank you.
Thank you.